Okay, greetings to everybody out there in internet land. Welcome to one of numerous consultation sessions that we'll be holding on proposed amendments to the Aboriginal Affairs Planning Authority Act. Before we commence, I would just like to acknowledge the traditional owners and the lands upon which we meet and pay respect to elders past and present. My name's Darren Corr. I'm an Executive Director with the Land Use Management Division of the Department of Planning, Lands and Heritage. As many of you know, since 2017, the current government has sought to honour an election commitment of divesting the entire ALT estate back into the direct control of government of Aboriginal people within 2 terms of government. Since then, DPLH, which gained responsibility for the ALT post the machinery of government changes, has made a concerted effort to uphold this commitment and, to be fair, received a level of funding way above anything previously allocated in the 20 years of trying to divest the ALT estate after the program was initiated in the wake of the 1996 Bonner Report. Despite the additional resources and some significant successes, progress is still slow, because without legislative reform, some of the structural issues that impede divestment cannot be rectified. In response, the government has now committed to those reforms, and we are here today to listen to what is being proposed. I've been involved with the ALT estate for a long time, and I'm genuinely excited about what we're about to embark upon and the approach we are adopting. So without further ceremony, I'll introduce you to the team of Sian Hanrahan, Emma Crean and Christopher James, who will go through the details. Thanks very much.
Thank you, Darren. We'll just share the presentation with you all now, at the moment. Okay, hopefully you can all see the presentation now. Okay, as Darren mentioned, my name's Sian Hanrahan and I'm the Director of Native Title Agreements and Partnerships at the Department of Planning, Lands and Heritage. As many of you know, the state government is committed to the divestment of the Aboriginal Lands Trust estate into the direct control of Aboriginal people. Changes are proposed to the Aboriginal Affairs Planning Authority Act to maximise opportunities for divestment and increase Aboriginal land ownership and management, economic activity and improved outcomes for Aboriginal communities. Consultation is now underway on proposed changes to the Act, which will streamline divestment of reserve lands, replace outdated terms and clearly define consultation requirements for stakeholders and the Aboriginal Lands Trust. Feedback received from this consultation will inform the drafting of a draft amendment bill, which will be followed by a further round of consultation and then introduction into Parliament in due course. Through this presentation, I'll give you an overview of what is the Aboriginal Affairs Planning Authority Act, what is the Aboriginal Lands Trust estate, why does the Act need to be changed, what are the proposed changes, what will not change in the Act, what else the government is working on, and lastly, what are the next steps from here. There'll be an opportunity to ask questions at the end of the presentation through using the Q&A icon at the top of your screen. And lastly, this presentation is intended to complement materials on our website, and if you haven't seen them, we recommend that you do. So firstly, what is the Aboriginal Affairs Planning Authority Act and how does it relate to Aboriginal Lands Trust divestment? The Aboriginal Affairs Planning Authority Act was made in 1972 to provide consultation and other services for the economic, social and cultural advancement of Western Australia's Aboriginal people. The Act established 4 statutory bodies, being the Aboriginal Affairs Planning Authority, the Aboriginal Lands Trust, the Aboriginal Advisory Council, and the Aboriginal Affairs Coordinating Committee. The Aboriginal Lands Trust, or ALT, was established to own and manage land on behalf of Western Australia's Aboriginal people. The Aboriginal Affairs Planning Authority was once a government agency with its own staff, but is now simply the Minister for Aboriginal Affairs. It also owns and manages land on behalf of Aboriginal people. Our department, the Department of Planning, Lands and Heritage, looks after the land management functions of the Act, as well as the Aboriginal Lands Trust, with the Department of the Premier and Cabinet looking after the other functions of the Act and the other 2 statutory bodies. So the focus of this presentation, and indeed the ALT divestment discussion, is on the Aboriginal Lands Trust and the Aboriginal Affairs Planning Authority. So what is the Aboriginal Lands Trust estate, or otherwise known as the ALT estate? So it refers to land that is owned or managed either together or separately by the Aboriginal Lands Trust and the Aboriginal Affairs Planning Authority. Much of the land in the ALT estate was formerly native welfare reserves, which have subsequently transferred over to the Aboriginal Lands Trust or the authority after the AAPA Act was enacted. There are currently 301 properties within the ALT estate, located all over Western Australia. The Aboriginal Lands Trust and the Aboriginal Affairs Planning Authority own and manage land in various tenures, including freehold, special leases, pastoral leases, reserves under the Land Administration Act, and Part 3 reserved lands under the Aboriginal Affairs Planning Authority Act, with Aboriginal communities located across each of these tenures. This is a snapshot of the Aboriginal Lands Trust estate as it currently is. It covers 22 million hectares of land, or just under 9% of Western Australia. There are 400 leases and subleases of the Aboriginal Lands Trust estate. There are 81 reserves that are proclaimed under Part 3, otherwise known as Part 3 reserved lands, and that makes up around 93% of the estate. There are 93 native title determinations or claims, 143 permanent communities and many more seasonal ones, and there are approximately 12,000 people living across the estate. So in 2017, the state government made a commitment to divest the entire Aboriginal Lands Trust estate, and essentially that means returning land in the ALT estate into the direct control of Aboriginal people or entities, so the Aboriginal Lands Trust no longer has a say about how that land is managed. The goal of divestment is for Aboriginal people to be able to use land tenure rights to support long-lasting Aboriginal social, cultural and economic outcomes. The department has been working with a number of Aboriginal communities, leaseholders and native title holders to divest some properties within the estate. And since 2017, when the commitment was made, a total of 71 properties have been approved by the Aboriginal Lands Trust and the Minister for Aboriginal Affairs for divestment. So moving on now to why the Act needs to change. Throughout our divestment engagements with Aboriginal communities, leaseholders and native title holders, a number of challenges with divestment kept coming up. Some of these challenges were directly about how the Act worked and its limitations. Through those consultations, we have identified 5 main reasons why the Aboriginal Affairs Planning Authority Act needs to change. Firstly, the AAPA Act is 50 years old, uses outdated terminology and does not consider the Native Title Act. The Aboriginal Lands Trust's duty to consult before it makes decisions about the use and management of the Aboriginal Lands Trust estate is not clear. Part 3 reserved lands cannot be managed by an Aboriginal entity or person. Red tape in the Act makes divestment of Part 3 reserved lands difficult. And lastly, lots of Aboriginal people have a connection to the ALT estate, and sometimes there are different views about how it should be managed or divested. So now I'll go through each of the proposed changes, explain why they are needed by identifying each of the problems with the Act and how we propose to solve them. We're proposing 7 key changes to the AAPA Act. we're proposing to make the Aboriginal Affairs Planning Authority Act consistent with the Aboriginal Empowerment Strategy, update the terminology used to refer to Aboriginal people, make it clear what the Aboriginal Lands Trust must do when it consults, make it possible for Part 3 reserved lands to be managed by an Aboriginal entity, make it easier and quicker to divest the Aboriginal Lands Trust estate, make it easier to change the boundaries of Part 3 reserved lands so they no longer overlap roads and public utilities, and lastly, abolish the Aboriginal Lands Trust once all of its land has been divested and remove the power to make new Part 3 reserved lands. So to the first problem, as I mentioned, the Aboriginal Affairs Planning Authority Act is 50 years old. The parts relating to the Aboriginal Lands Trust estate have never changed, despite an attempt in 1985 to do so. The original purpose of the Aboriginal Affairs Planning Authority Act, which was to control and oversee the welfare of Aboriginal people, is outdated and does not reflect the state government's objectives of supporting the empowerment and self-determination of Aboriginal people. And lastly, the Act does not specifically recognise the rights of native title holders under the Native Title Act. So the proposed solution is to make the Act consistent with the Aboriginal Empowerment Strategy through a focus on improved engagement and increasing social, cultural and economic opportunities through land ownership or management. And make it clear that a key purpose of the Act is to meet the aspirations of Aboriginal people through the divestment of the Aboriginal Lands Trust estate. Now to the second problem. The Act uses definitions of Aboriginal and person of Aboriginal descent that do not reflect current understandings and laws. The Aboriginal Affairs Planning Authority Act refers to Aboriginal inhabitants, which may not include all Aboriginal people who have an interest in the ALT estate. And the AAPA Act predates the Native Title Act and has not been amended to bring it into line with that Act. The proposed changes to the Act will bring it in line with other laws in how it defines Aboriginal people by including a new definition of Aboriginal person who is wholly or partly descended from the original inhabitants of Australia and identifies as an Aboriginal person and is accepted as an Aboriginal person by an Aboriginal community in which the person lives or with which the person identifies. The problem number 3. The Act says the Aboriginal Lands Trust must use and manage the ALT estate in accordance with the wish of the Aboriginal inhabitants of the area, so far as that can be ascertained and is practicable. This means that before the Aboriginal Lands Trust makes a decision about using, managing and divesting the ALT estate, it must consult with Aboriginal inhabitants and ask them what they think. The Act does not define who Aboriginal inhabitants of the area is or what is practicable. This means there is uncertainty in who the Aboriginal Lands Trust must talk to and how. So we need to make sure that all Aboriginal stakeholders with an interest in a property in the ALT estate have the opportunity to be consulted about the use, management or divestment of that property and express their views. The proposed changes to the Act will include a definition of Aboriginal stakeholder defined by a geographic area to include relevant native title holders and claimants, leaseholders, communities and residents. It will require consultation with those stakeholders before the Aboriginal Lands Trust makes a decision relating to the use, management or divestment of a property. It will also include a defined timeframe for the stakeholders to provide a response to the Aboriginal Lands Trust. And lastly, if a response is not received within the time given, the Aboriginal Lands Trust will be able to proceed with its decision. That's problem number 4. 93% of the ALT estate is reserves proclaimed under Part 3 of the Act, otherwise known as Part 3 reserves or Part 3 reserved lands. Part 3 reserved lands are usually reserved for the use and benefit of Aboriginal people and were mostly areas of land set aside under the old Native Welfare Act. It was recognised by the government of the day that these areas deserve protection to ensure they are always available for Aboriginal people to use and enjoy. When the Act was made in 1972, these reserves were placed under the management of either the Aboriginal Affairs Planning Authority or the Aboriginal Lands Trust, and given special protections through the proclamation made by the Governor that brings the reserves under the operation of Part 3. The limitation in the Act, though, is that Part 3 reserve lands can only be managed by the Aboriginal Affairs Planning Authority or the Aboriginal Lands Trust on trust for Aboriginal people and can't be managed by Aboriginal people themselves. Therefore, to divest Part 3 reserve lands into the direct control of Aboriginal people, they must first be deproclaimed, thus removing their special protections. So the special protections given to Part 3 reserve lands are that all non-Aboriginal people, other than government officers and parliamentarians, must have a permit before they enter or remain on the reserves. It is an offence of trespass for any non-Aboriginal person to enter or remain on Part 3 reserve lands without a permit. Parliamentary approval is required to deproclaim, and that is to cancel or change the boundaries of Part 3 reserve lands. The Minister for Mines and Petroleum must consult with the Minister for Aboriginal Affairs before giving a mining company permission to explore or mine. And lastly, it requires government agencies to have the approval of the Aboriginal Affairs Planning Authority before they grant any interest over Part 3 reserve lands, with the exception of mining and petroleum interests. So these protections are used by Aboriginal communities, leaseholders and native title holders to control who enters their communities and how they behave, to safeguard the privacy of communities, to negotiate with mining companies and tourism operators, to protect cultural heritage and look after the environment. For some Aboriginal communities, leaseholders or native title holders who rely on and benefit from these protections, there's a reluctance to give them up. There is currently no form of tenure available under the Land Administration Act that provides the protections given to Part 3 reserve lands to the same degree and under the same conditions as Part 3 reserve land protections. So the solution, the proposed changes to the Act will give an Aboriginal entity the option of managing Part 3 reserve lands, and that will be along with the other tenure options already available. It will give an Aboriginal entity the power to grant its own permits. It will give them the power to grant leases. It will keep the same treatment under the Mining Act, and that is the Minister for Mines will continue to have to consult with the Minister for Aboriginal Affairs before giving a mining company permission to explore or mine, and will keep the rule that non-Aboriginal people must have a permit to enter those reserved lands. It's problem number 5. The Aboriginal Affairs Planning Authority Act requires all decisions about the use, management and divestment of the ALT estate to have the Aboriginal Lands Trust approval after consultation with Aboriginal stakeholders and the approval of the Minister for Aboriginal Affairs. The Act also includes several additional parliamentary steps before Part 3 reserve lands can be divested. And they are: the Minister for Aboriginal Affairs must make a recommendation to the Governor. The Aboriginal Affairs Planning Authority, who is also the Minister, must be referred to and prepare a report. The report is then presented to both Houses of Parliament, where it must sit for 14 days, and then either House may pass a resolution rejecting the recommendation to either cancel or change the boundaries of a Part 3 reserve land. This makes divestment of the whole or part of Part 3 reserve lands difficult, lengthy and uncertain. So the proposed changes to the Act will remove the parliamentary steps for divestment if we are deproclaiming Part 3 reserve lands so we can divest them, or if we are changing the boundaries of Part 3 reserve lands so we can divest a portion of them. There will be no change to the requirements for the Aboriginal Lands Trust to consult with Aboriginal stakeholders, for the Aboriginal stakeholders to make a recommendation to the Aboriginal Lands Trust, and for the Minister to approve the deproclamation or the change of boundaries. Problem number 6. There are telephone, power, water and gas services and main roads located on Part 3 reserve lands across the state, And this creates uncertainty about who is responsible for looking after those services and roads. Changing the boundaries of Part 3 reserve land so they don't overlap with public utility services and roads requires the same parliamentary steps. The proposed changes of the Act will remove the parliamentary steps if there is support from Aboriginal stakeholders to change the boundaries of the reserve lands so they don't overlap power, water, telephone and gas service infrastructure or roads. The infrastructure and roads can then be put on appropriate land tenure and placed under the management of the agency responsible for them. And there'll be no change to the requirements for the Aboriginal Lands Trust to consult with Aboriginal stakeholders, for those stakeholders to make a recommendation to the Aboriginal Lands Trust, and for the Minister to approve the change of boundaries. Importantly, all other deproclamations or cancellations of the reserves or changes to boundaries will still need to go through the parliamentary steps. And problem number 7. So consistent with the state government's commitment to divest the ALT estate, we need to think about the role of the Aboriginal Lands Trust once all of its land has been divested and the operation of Part 3 of the Act. So the proposed changes to the Act will abolish the Aboriginal Lands Trust after all of its land has been divested because its job has been done. It will remove the power to place divested Part 3 reserve lands under the control and management of the Aboriginal Lands Trust, and it will remove the power to proclaim any new reserves under Part 3. So now to what will not change through the amendments. As already explained, the proposed changes are aimed at maximising opportunities for divestment through thorough consultation with all relevant stakeholders and removing red tape. The proposed changes will not impact any existing rights of leaseholders of the ALT estate, residents, native title holders and claimants, and existing permit holders. They will also not change the ALT's duty to consult with Aboriginal stakeholders, the Minister's obligation to approve land use management and divestment decisions of the Aboriginal Lands Trust, and the existing parliamentary steps, aside from the divestments, are in respect of public utilities and roads. The proposed amendments will, however, open up opportunities for existing interest holders to have land divested directly to them. So now to what else the government is working on. So the state government recognises that the proposed changes to the Act only go part of the way to addressing the challenges of divestment. In divestment discussions with Aboriginal communities, leaseholders and native title holders, we have heard that they are concerned about making sure the land is fit for purpose and they have sufficient administrative, legal and financial support to actively participate in divestment discussions and be able to provide free, prior and informed consent to divestment. They want to have robust and durable governance structures and sufficient capacity and resources to meet the ongoing financial and administrative demands of land ownership and management. They do not want to take on land that is a liability and want to make sure that any risks, contamination and hazards are addressed before divestment. And lastly, that they are in a position to take advantage of opportunities that come with land ownership and management. We have heard these concerns and are currently investigating options to expand the current pre-divestment support to encourage greater engagement by Aboriginal communities, leaseholders and native title holders in the divestment process, to build financial and governance capability, to assist with the development of strategic plans and the development of business and development support for proposed activities, to assist with the development of land use and leasing policies and procedures, and ensure that the land is divested free from hazards, risks and contamination. We are also investigating providing post-divestment support to assist Aboriginal corporations and entities with their land management responsibilities when they become a landowner or manager. So what are the next steps? The department is currently undertaking consultations in Perth and several regional centres We were in Albany yesterday and we're heading to Port Hedland, Newman, Roebourne, Kununurra, Halls Creek, Fitzroy Crossing, Derby, Broome, Geraldton, Carnarvon and Kalgoorlie. This round of consultation closes on the 10th of June and all feedback will inform the drafting of the amendment bill. Once the bill has been finalised, the department will undertake a further round of consultations on the bill, which will be introduced into Parliament in due course. So now to questions. There are our contact details on the page there. So our website, our dedicated website. There's also an opportunity for you to provide your feedback through the online survey, or also to send any questions through to our email address, and all of these details are on our website.